So status is very important because the status determines how, excuse me, the status is very important because status determines how the courts in any legal venue or lawful venue will handle you. Okay? Status has to come first in all things, before all things, such as the reclamation, even, or any lawful matter. An individual's status determines their entitlements and rights. Not everyone has the same entitlements or rights. Take note of the Constitution where it says elected officials cannot use titles of nobility. Titles of nobility are El Bey, Dey, Ali, or El Bey. Those are titles of nobility for the Asiatics, for those of us who have attached ourselves back to the land, and those of us whose ancestors have already proclaimed those names. Many second generation Moors are also named by these titles of nobility. The followers of the Prophet Noble Jew Ali, they are too named and have adopted their titles of nobility because these titles of nobility attach you to the land. So, this is the importance of making a proclamation, making a reclamation. It has to do, reclamation has to do with reclaiming your status as well as the land of your ancestry. So, if you have not yet claimed your status or your title of nobility, you can use a simple affidavit like this one, 2 pages. I've used this for many years and shut down many court cases and unlawful encroachments upon my liberties with just 2 pages. Myself and several of my tribal members, we use this affidavit. In my territory in North Carolina, it's pursuant to North Carolina statute section 1-85, which states affidavits on hearing for removal with removal ordered. No action, civil or criminal, shall be removed unless the affidavit sets forth particularly and in detail the ground of application. So, when you claim your status and you put that on the record, you're simply removing the case to tribal jurisdiction or you getting it removed, period. Because that's your title of nobility, your status, your indigenous claims are not proper in a court of a state or corporate court venue. So this affidavit is very important and it makes the opposing venue take note of your status. Nothing can move past your status regarding any and all court presentations wherein the state and federal United States District Superior Federal Courts notice to states, municipalities, law enforcement, and court officers. Notice to the principal is notice to the agent. And notice to the agent is notice to the principal. So this is how we would proceed in any venue, in any situation. it has to be dealt with first by status, because status is going to determine your entitlements, your protections under the law, and your rights under the law. Not everybody has the same set of rights. This is what they don't tell you in school. This is what they're not going to tell you in the law offices and the courts. You have to know this. Ignorance of the law is no excuse. That's why they treat people in any kind of way they want to, because it's in the law as well. Ignorance of the law is no excuse. So if you don't know the law, that is not their problem. So it's very important that we, as astute individuals with intelligence, learn the law, especially when it pertains to you, especially when you are actually attached to the land. So you should know the law, especially the laws of the land. So in this affidavit, I let them know, and this is some of the verbiage. Now comes NTL Bay, living sole executor of her own estate, because everything that's happening around us has to do with an estate, a trust estate that has schooled us on, nobody has informed us of, nobody has administered our estates properly. Because if they had administered our estates properly, we wouldn't be in debt. We would know that we are shareholders and heirs to the land. We would know that our inheritance, a portion of our inheritance, is being traded on the stock exchange and being used as an asset. This is why they don't want to sign these over to us, because they're worth something. We are worth more than gold in America. Each one of us who has an indigenous status. And the reason this has been kept from us, the reason that our status has, our true status and titles of nobility have and royalties have been kept from us, is because of the estate attached to us. We are wealthy in America. We were born wealthy in America. This is what they're not telling us. This is what the so-called governance is not telling us. So me knowing this, approximately 20 years ago, over 20 years ago now, I took back the estate for me, myself, and my children. So that means everything that's being done in commerce with our names, our entitlements, and our estate and our trust has to go through me. They cannot just use our chattel paper. So until you take it back, you are considered their chattel paper property. You have to take back your estate on paper. So a lot of people, they ask the question, we don't have to, or why should we have to tell these people who we are when they already know who we are? It's not about telling them who you are. They do know who you are, but it is about a law that states that if you do not enforce your rights to your entitlements, then you have been deemed to have abandoned them. So it's very important that you assert yourself as the owner and the executor of your own estate. If you have children, do the same for them. And there's various ways that you can do that. and you have to notify the individuals within the governments, such as the Secretary of State, who's handling the trust. Anywhere that you see an individual in public office being named a trustee, they are handling estates that belong to us, we the people. So that's who you make your demands to. And I have long since done that on the record, duly filed. When it's duly filed, that means it is filed in the courts and it is filed in the county records. For the indigenous inhabitants and the people of the land, your courthouse is in the county. It's the county records, the county recorder. Your affidavit stands as law. So that's what this is. And I have plenty of them on the public record. This is an affidavit of immunity and a verified statement of Ninti Elbe. And it's on the record. So if anybody comes looking for documentation, paperwork, any jacket on me, as they call it in law enforcement, they're going to see this. And they're going to know right away that this lady knows something and we cannot touch her. Okay? So, all throughout my time in the South for the past 20 years, I've probably been falsely arrested over 25 times, something like that, maybe approximately 30 times, and it always gets dismissed. So that tells you right there it's a pattern of harassment, so on and so forth. But because I had my paperwork together, they could not ever keep me. Okay? The last time when I turned 50 years old, a couple of years ago, they kept me for 13 months. But that was on some other stuff. They was all the way on some other stuff regarding that situation. I'll talk about that at a different time. But the point is, they cannot charge me with anything. A person that has their status properly noted and filed for the record cannot be touched, especially when they are an indigenous inhabitant. And I'm going to show you why. So, this statement lets them know that I'm the executor of my own estate, having taken first lien rights of ownership over all of her and her children's chattel paper property, names and numbers. Cannot be now or in the future be considered a minor. It's very important that you know what being a minor is. You do not want to be considered black. You do not want to be considered a minor. These um, denotations do not have any protection under the law. They know melanated people overpopulate them all over the earth, but yet they're calling us minors. See, you have to watch the verbiage that you agree to. Minor, and being a minor at law means that you cannot handle your own affairs in your own estate. So the establishment, who have established themselves as a government who is not in essence a government at all, they're always in the process or in the business of taking you out of your proper status so that they can take over and handle your estate. Whether it's calling you a minor, trying to get you to agree to some type of conservatorship, or trying to get you to waive your rights, or trying to get you to agree to let them be your fiduciary in any way. All of these are ways for them to handle your estate. We don't want that. This is why we have to be astute and we have to be intelligent in learning how to handle our own estates, especially in America. If you were born as an aborigine, blood type A, blood type AB, you need to learn the law. You need to learn how to administer your own estate because there's affairs that are going on dealing with your estate that you need to know about. Now that you know, you have to do better and you have to claim these things for yourself. So I go on to say in this affidavit, there shall be no derivatives thereof of our names, contracts created knowingly or unknowingly from the time of creation. They are all owned by Ninti El Bay. Further standing, Ninti El Bay is a member of, at this time, Yamasee Tribe Moorish National. That's how old this is. This is about 20 years old. I now have my own tribe for the last 10 years. Cherokee Nation of Moors, Charlotte, North Carolina, tribal territory. Okay. And the jurisdiction for her matters does not lie within any Admiralty maritime court system operating on water. And that's what the whole system is operating on because they do not have the permission, the authority, or the rights to operate as a landlord. And in order for them to operate as a landlord or operate on the land, they will have to have a contract to do commerce, to be leased in, or to be a landlord on the land. They don't have that. So they're operating under Admiralty maritime law in the courts. So I go on to say NTL Bay is not a party, and you can inject or add your name to this. I give this affidavit out. You can email me if you want a copy of this. Empress Ninti El Bay is not a party to any contracts by the state of North Carolina or any other state that would bind or waive her sovereign immunity at law, and nor tribal immunity. I stand on tribal immunity and sovereign immunity, tribal immunity, and the doctrines, all the doctrines of immunity. Okay. All adhesive contracts regarding traffic matters have been satisfied and appeared to by special visitation. Driving records must be abated and made clear of all failures to appear. This is a form of harassment that they were doing to me. Keep trying to get me in contract when they know what I stand for. They know what my status is lawfully noted on the record as. You have to really be strong to stand up against the strong arm of the establishment, especially when you know that you are standing in the right of way. Okay, this is one of the devices that the state is using to falsely impede Ninti El Bay's movement in commerce on the land in which she has aboriginal title to and is considered part and parcel thereof. The state of North Carolina's efforts to defame the character of the Moors has already cost the corporate de facto of state of North Carolina $101,006,000, as indicated on the state's ledger report for settlements since 2011. And it shows up. It's probably still showing up every year because they refuse to pay it out. That's a claim for a case that I wrote in 2010. Department of Justice sued the state of North Carolina in regards to that claim and paid out $101,006,000. But rather than them paying it to me and the family of the Moors, which I had indicated on the case, they rather keep it on their ledger and their books to keep monetizing on it. So that's one of the grievances that they have against me, because I will not walk away from something that I know I'm entitled to. So then I go on to say this essentially means that Congress has the final word as to the scope of tribal sovereignty and the powers that tribes are able to exercise. Point number 21 in this affidavit that came from another document of mine states that one exception to this general rule is the doctrine of tribal sovereign immunity. Tribal sovereign immunity is part of federal common law. Tribal immunity is part of federal common law. Tribal sovereign immunity is part of federal common law. It was not created by any statute or act of Congress. Rather, the Supreme Court first identified it, and its exact boundaries have been further defined through a substantial body of case laws. The doctrine of tribal immunity, the pardon me, the doctrine of sovereign. I have gotten away from the word sovereign because they have tainted it so much. The doctrine of tribal sovereign immunity. The Supreme Court first acknowledged tribal sovereign immunity in Turner versus United States, in which a non-Indian lessee was barred from suing an Indian tribe. They wanted to sue this tribe for alleged damage done to his property. A foreign individual or entity sue somebody who's of indigenous status on their own land. It cannot be done. It's in the law. Just study Title 25 and you'll learn the law as it pertains to how they are supposed to treat us federally, whether so-called federally recognized or non-federally recognized. Once you claim and proclaim who you are and you notice them of that, that's what has to be respected. Period. Nobody can tell you who you are. And now that it's coming down to the nitty gritty, your blood has to tell them who you are. They cannot deny who you are. They already know in the records. They are thirsty vampires for data and census information. So they know exactly who each and every last one of us is in America. So don't let them fool you. So the next case law talks about how the court stated that it is the general law that, like other governments, municipal as well as state, tribes are free from liability for injuries to persons or property. Once again, let me make that clear. The court stated that it is the general law. This is like a staple of law, a doctrine of law. Once there's so many cases decided in the same fashion, it does not have to be adjudicated anymore. It is a doctrine of law. It is a generally known law in all courts. Okay, that the court stated, this is general law, that like other governments, municipal as well as state, tribes are free from liability for injuries to persons or property. This is why they wanted to snatch tribal members and tribes up from the land and put them in a certain designated place, because the tribes and the tribal members have a power on the land. They are the true electors. We, the people of the land, are the true beneficiaries, electors, and owners and heirs of the land, who have to be respected and cannot be charged for a crime on their own land. Let me continue. The next one is in the United States versus United States Fidelity and Guarantee Company. The Supreme Court reiterated that Indian tribes are immune from suit when it voided a monetary judgment from a previous proceeding against the Choctaw Chickasaw nations. Now you see why they don't want you to have your proper status. Okay? This is why. Because there's power in who you are, there's power in your status. You cannot be charged for a crime on your own land. This is why they want to shut people like me up from telling you this. This is very important. This is power. It's power in knowing who you are, it's power in standing in your proper status. The Supreme Court reiterated that Indian tribes are immune from suit, which it should be Aborigine tribes. Of course, they when they took over, the opposition took over, they changed the Bible, they changed the text in the law eh, to suit themselves. Remember, there was no Indian here in America. Indians are in India, period. But this is talking about you. And this is another thing that was commonly done to confuse us. They want to put something in the law that depicts a group that does not look like us. So, therefore, everything they have done has been made and done to confuse. So, you don't know growing up, you don't know who you are. You don't think you are, Indian. So, of course, if you think you from somewhere else, you think you from Africa, or you think you entitled, or you don't think you have any entitlements. You don't think you're entitled to the land. You don't think you're entitled to any any benefits from the land, royalties from the land. Because when you own the land, when you own something, they have to pay you royalties for that. So, of course, the opposition does not want you to know who you are. The opposition does not want you to know that you have these immunities. The opposition does not want you to realize that you are the true Indian tribes that they're describing in the law, who have immunity on their own land. The Supreme Court reiterated that Indian tribes are immune from suit when it voided a monetary judgment from a previous proceeding that came against the Choctaw and Chickasaw nations. The next one, it stated that tribes do not waive their sovereign immunity when they fail to object to cross claims and litigation. Now, that goes to show you right there that you don't have to answer any summons. You don't have to jump through any hoops. Once you put it on the record, any valid, lawful, legal, lawful professional can find it, and everybody in the public can find it. It's displayed in an inconspicuous manner that you are of indigenous status. That's it. They can look up the records. They can look up your name and find everything on you when it's filed in the county or the courts. So there should be no summons or anybody knocking on your door once you tell them lawfully by affidavit form, which cannot be rebutted or refuted, who you are. And your status cannot be waived just because you don't answer a cross claim or litigation. This is seated as law. This is seated in doctrines of tribal law. That's why it's important to know who you are, because once you know who you are and your status, you know the laws that protect you. This is what you have to stand on. This is your power in any situation that is coming against you. Next, we go on. You have Pulliam Tribe, um, Pulliup Tribe Inc. versus Department of Game of State of Washington. The court held that a state could not sue a tribe to enforce its fishing regulations in in Indian country, absent an effective waiver or consent from either the tribe or the United States. This is why it's so important that you stand your ground and you know the law. Because if you don't, they'll try to get you into various contracts, because again, they want you to consent. And it can only be your status, and a contract can only be voided by your own waiver or consent to waive. So always reserve your rights in your dealings, in your doings, in your contracts, and make sure that everybody knows who's involved in those contracts and doings, that you are of the land. It was funny, the other day I was walking the dog, and a man popped out of nowhere, an older man of the pale persuasion, and I could tell by how he was dressed who sent him. So the way I look at things and the way the average person looks at things will be totally different because of my experiences of what I've been through. So I know what I'm dealing with. He pops out of nowhere and tells me, "Yeah, when your dog poops, put it in the bucket over here." I was walking past an apartment building. I had to stop and remain firm with him and let him know this is tribal land. See, they try to play their games. They know who I am. He know what I do and what I represent on the land every day. Yet and still, he feel somebody sent him. He wanted to try me, as we used to say. They want to try your gangster. They want to see if you gonna stand on all 10 toes when it come down to it, to a face-to-face confrontation. This is what they do. I simply told him immediately, this is tribal land. I'm indigenous to this land. This is tribal land. And he had to walk away. Period. He know he don't have no bones in his on this land, no dog in this fight. But he wanted to see if I was strong enough. They always coming with, some kind of group backing them. As I always say, it's a spiritual battle. We struggle not with flesh and bone, but by spiritual principalities. So that being said, they know they cannot come into somebody else's home and kick their feet up on their coffee table and start ordering them around. That's how that looks in law. Everybody in law, everybody in the world knows who we are. One of the one of the prime ministers or presidents had and from South America, Colombia. She made a speech last week, I believe, and said openly that the so-called black people of America are the royalty, are the true royalty in America. So, the more we push, the more it's coming out and they have to tell the truth. But everybody knows this. So it's the same thing. Nobody can come onto your land and tell you what to do. Period. It don't work like that. And here is 2 pages of case law to solidify that. 2 pages of case law that I've been using for years to smack them upside the head with the law. So I'm 100% lawful, but here we are with my face plastered all over the news as being unlawful. This is what you call a switch, a bait and switch. This is what they like to do. The bold faced liars, they want to depict a person to be everything and opposite of who they are. That's just like they do everything. They turn it around. They try their best to turn it around. So what I'm telling you in saying that is you have to know the element, the individuals, the establishment that we have been dealing with. They're bold-faced liars who will look you right in your face and tell a lie. I'm speaking from experience. I'm speaking from experience of what I know of these beings that have been in control on the land. There's no truth in them. You can't expect them to tell the truth because they sitting in your stuff. They sitting on your land, occupying something that don't belong to them, that they ancestors and great uh, grandparents stole. So why would they tell us the truth? They said everything but the truth in their his story books. Didn't tell us it was the truth. They didn't have to. They just told you it was his story because that's what it was. That doesn't mean it was true. That means that he came in with his phallic system and made everything about him and whatever he wanted us to know and brainwashed them. And in 2 generations, they will not know who they are. That's all they cared about. So you have to do your due diligence in learning what is real and what is not in the timeline legacy of the Aborigine of America and worldwide. This right here is a prime example. It's pages and pages and pages. I only put 2 pages worth of case law dealing with tribal immunity in this affidavit, and I shut them down every time for years. It's all about knowing who you are. This is the contention that they have with a person like me. And I don't budge. I'm stubborn. I don't back down because I know better. And that's how you have to be. You have to be relentless. These beings are relentless in their efforts to bait and switch and walk in your shoes. They will do anything and everything. They have shown me they will do anything and everything to change the narrative, steal inheritances, commit white collar crimes to do this, and do it all under the auspice of law. Okay? So that's why you got to come like this with all guns blazing, so much so that they cannot turn you away. They cannot beat you. Okay? I have never lost a court case. No matter what they tried to put in the news and all of this different stuff, I know I know it to be true that they are both faced liars. They had me all in the news several times saying I had 21 years in jail one time. And I didn't serve, not at that time, I didn't serve not one day. They had a false court session. This is when I realized they do false court sessions. I'm telling you, they have a whole system of people to help them commit fraud. And if you don't know what you dealing with, you have to stay out of it until you can learn the law. And right here, I'm giving it to you. There's case laws upon case laws. So let's look at the next one. That you cannot waive your rights no matter what anybody says. That's in the case law. And Aborigine tribe or tribal members cannot effectively waive their rights no matter what anybody says. So that's why status is important, because you know how sometimes they can say you didn't show up in court. They'll try to use whatever. Failure to appear. When I already told you in this affidavit, put it in the court and put it in the county, that I don't have to answer nothing. I don't have to abide by any of your policy, because that's what it is, policy, or your invitations. So for years, after I smashed them and hit them in the head so many times, they stopped bothering me. Until these recent years, when it was really getting heavy to the point where I was really moving in the capacity of a ruler on the land, shut down the courthouse for 9 months, all of that, the whole shot. It was too much. It was just too much for them. They couldn't take it. It was like, no, go and get her. But these are the laws, tribal laws that I put in the affidavit, and this has saved so many others over the years who I've shared this with. Get out of court cases, child support, unlawful arrest, you name it, because your status determines how you are handled in the courts and law enforcement. So in Santa Clara, Pablo versus Martinez, the court expanded on Puliap's holding by stating that any waiver of tribal immunity must be unequivocally expressed. Unequivocally expressed. We do not express or give consent to waiving our rights at no time. Don't ever waive your rights, always reserve your rights. Moving on, we have in Oklahoma, Tax Commission versus Citizen Band Potawatomi Indian Tribe. The court rejected a contention that was nearly identical to the one it had addressed in United States Fidelity over a half a century prior, further solidifying the status of tribal immunity as black letter law. Okay, you have to go and do your research. What is black letter law? Very important. It means it's settled, it's staple. It cannot be changed or altered. In Kiowa Tribe of Oklahoma versus Manufacturing Technologies, Inc. The Supreme Court, for the first time, declared that Native American tribes were immune from suit for activities engaged in and outside of Indian country. I doubt if that was the first time. They always saying something is the first time because it's the first time for them. They never experienced anything in civilization, in law, in court, in upper echelon until 125 years ago. The timeline of legacy that they talk about, 500 years to 400 to 500 years of slavery, was for the Slavics that were in the caves of Europa. It was not for us. They injected that timeline into their history because they had no legacy or timeline. So everything is new and discovery for them, not for us. Moving on. So it says, the Supreme Court, for the first time, quote unquote, declared that Native American tribes were immune from suit for activities engaged in or outside of Indian country. Specifically, the court declared tribes enjoy immunity from suits on contracts, whether those contracts involve governmental or commercial activities, and whether they were made on or off a reservation. Do you see how powerful that is? That is a doctrine of tribal immunity. That is a staple within tribal immunity. It goes on further in another case to say the court did express some hesitation in reaching this decision, stating that there are reasons to doubt the wisdom of perpetuating the doctrine of tribal immunity. They can say all of the hesitation they want. It is stapled as law going back since the beginning of the black letter law. So it does not matter their opinion. We're not dealing with opinion or conjecture here. Next, tribal immunity extends beyond what is needed to safeguard tribal self-governance. That's a matter of opinion. The court stated, and this consideration might suggest a need to abrogate tribal immunity. This is where, of course, they see the power in it. They're going to try to abrogate tribal immunity, but that is only an opinion. It is not ever happening, so don't worry. However, because Congress had not specifically abrogated tribal immunity in the context of the case, the court declined to revisit its case law and chose to defer to Congress. That's what they have to do. It's not a choice. They have to defer to the law. And Congress is the body, and the International Courts of Justice, and now the International Courts of the Land, uphold the laws of the land and preserve the rights of the Aborigine of America and indigenous populations of the world. So it does not matter. The judge, in this grand scheme of hierarchy, the judge, a federal judge, Supreme Court judge, any judge, is at the bottom of the list. They have to abide by the electors, the beneficiaries of the land, and the international courts, Congress, and the tribal courts of the land are the gatekeepers and the protectors of those rights and entitlements for us as Aborigines of America. So if you want to see more laws, if you want this document, you can email me and I can send it to you. That is, and it's all in the law. You can find these laws in your state, in your local state, and federal laws. Study Title 25 and stand on the laws of of Title 25. In North Carolina, the law is Chapter 25, Section 15A-954, Section 9. The defendant has been granted immunity by law from prosecution. That is the straw that breaks the camel's back every time. So now I have brought these laws forward. I have brought these um, staples of law, these doctrines of law, these international laws to life in this affidavit. And to clinch it all together, I bring the law of this state to make them bow down to that immunity. And that is what has to be invoked for a person, an individual that is attached to the land and is indigenous and has the claims of status of being immune from policies, procedures, or any adverse matters at law. So that has been Empress Ninti L. Bay, taking back the land the right way. That has been Empress Ninti L. Bay, taking back the land the right way. If there's any questions in the chat, I'll check real quick. Okay, so that's going to be the end of this lesson, which we are calling Status and Tribal Immunity as it relates to the indigenous, aborigine, and aboriginals of America. Ashe, ashe, ashe. Till the next time, family. This is Empress Ninti L. Bay. I'll see y'all on the next one.